Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. First case on the calendar for oral argument is number 160, People v. Clark. Counsel for appellant is remote. Ms. Whiteside, good morning.
Good morning. Can you hear me?
Yes. You may commence.
Oh, okay. Your Honor, we are asking, so I'm Mary Whiteside on behalf of the appellant, and we're asking this court to undertake a weight of evidence review in this case and to independently review the entire record. We believe that upon review that an acquittal would not have been unreasonable, given that the only evidence linking Mr. Clark to the crime is Ms. Gottberg's identification. And we contend that there is reasonable doubt in her identification with Mr. Clark, however sincerely she believed it, and that it wasn't accurate, and that her increasing confidence over the multiple identifications gave the jury false confidence in the accuracy of her identification. When you review the other evidence in the case, there is nothing else that directly links Mr. Clark to this robbery. The other victim who experienced the exact same thing, who was seated in the driver's seat, did not identify Mr. Clark as the man that robbed him. And it's our contention that Mr. Clark did not commit this crime, and that the record shows that Ms. Gottberg's memory of the suspects is not consistent. She described the clothing worn by the man in black as a black hoodie, a sweater, a jacket. She described the other man as having red sweatpants, other times no sweatpants. The hoods were up or not up. They were bald. Other evidence shows that my client had hair at that time. And all of this makes perfect sense because these men were strangers. They were of a different race. She was under great stress with what looked like a gun pointed in her face. And science teaches us that under those conditions, it's hard for a person to encode the accurate details of a suspect, and it increases the chances of an inaccurate identification. After that, Ms. Gottberg then experienced suggestive police identification procedures and multiple identification, which compounds the suggestiveness of the...
Well, the first photo array ID was not suggestive, was it?
Well, I would contend that it is suggestive in the sense that Investigator O'Shaughnessy was not a double-blind administrator. He knew that Mr. Clark, Cadero Clark, was a suspect, and that the best practice would be for another investigator who doesn't know who the suspect is to administer the first photo array.
He didn't say anything to suggest to the victim which photograph to pick, did he?
There's no evidence of that. He could have, however, done something, and the science shows that there can be body language, things that are just not intentionally done, but are suggestive. So is it the worst of them? No, absolutely not. The first one. However, then we move on to the second identification photo arrays, because Ms. Gottberg initially picked Mr. Clark, but then immediately said she was unsure and asked to see new photo arrays. And then we go into the second photo array, which happened, shortly thereafter that same night. And that admittedly did not follow police procedures. Investigators admitted that.
Is it your position that the second photo array should have been 3 sets of photos, none of which included the defendant?
No. My suggestion is that the second photo array should have withheld the first photo array, and that the first photo array should not have been shown with the subsequent 3 new photo arrays, and that showing them all together with the markings that were on it did explicitly not follow the general orders and was inherently suggestive.
But Counselor, there were 4 separate identification procedures over a long period of time. Is that correct?
That is correct. But when you have suggestiveness and you have someone who has a change in memory, and memory does inherently change over time, you run into this commitment bias where you're remembering the photograph that you saw before, not necessarily the person that was there in the event with you. And the mind can confuse those things. That's what,
Ms. Whiteside, but on cross-examination, I was sort of focusing on just one line. After she talked about second-guessing herself at page 433, she then says almost immediately, "I never had doubt about his identity," on that same page. That's a pretty strong statement on cross-examination in particular. "I never had doubt." And the jury heard all that. Aren't we supposed to kind of defer to their weighing all the different things you mentioned and the people put in their brief? And shouldn't we generally defer to the jury in this kind of situation, given
well,
that testimony?
I don't think that I think you can weigh all of that. I'm not really challenging Ms. Gottberg's credibility. I think she sincerely believed that she didn't have any doubt. And what I'm arguing in my brief is that that we know more about the mind and how memories are encoded, and that her increasing confidence over time is not evidence of accuracy, and that you can't link the two, confidence and accuracy, but that it's very likely that a jury would do that would link confidence.
Yeah, look, Ms. Whiteside, I understand and I agree with you. We know now that mistaken ID, not somebody lying, but somebody who is mistaken in their identification, is the greatest cause of wrongful conviction. Matter of fact, that cause, there's more of those cases than all the other cases combined for wrongful conviction. We know that, especially here where you have a stranger ID, cross-racial, identification testimony or eyewitness testimony is the weakest form of evidence that we know of. We understand that. But here, there were multiple ID procedures. The defendant was also, it's not irrelevant that he was the brother of the other perpetrator. We know it was the other perpetrator because he pleaded guilty. Fruits of the crime were found at his house. So there is more than just this victim's ID. And so what are we to do when we have a one witness ID case? Can there never be a conviction with this type of evidence?
No, I don't think that's the case, but I think you have to look at the quality of her evidence and her changing. She wasn't consistent in her description of the suspects all the way through. You can see that she's not consistent with that. I would love to point out the fact that People's Exhibit 31, which is closed, that investigator O'Shaughnessy arrested my client in, that was never neither victim at trial ever identified those clothing as the clothing worn by the man in black. So that evidence came in purely by investigator O'Shaughnessy as the clothing that happened to be the clothing that my client was wearing, which is completely generic clothing. And I would disagree that it is a direct link that they were brothers. I mean, brothers can commit crimes. That doesn't mean that my client was the second person there. And the evidence linking the two together is extremely slim. He was at his mother's house twice. Okay. That doesn't show anything. When there was no proceeds of the robbery at my client's home, they searched that. No gun was ever found. The only thing linking the two is Ms. Gottberg's identification. And given the quality of her identification and the taint from the police suggestive procedures, that's not sufficient. And the science shows that multiple identification procedures only compound the original problem. It doesn't cure it. It actually makes it worse, and it makes her more confident going forward. And a jury isn't necessarily going to understand that her increasing confidence is actually evidence of could very well be evidence just of increasing confirmation bias.
I think we got it. Thank you, counsel.
Thank you.
Good morning, Amy Wollensack on behalf of the people. I plan to address point 1, the weight of the evidence issue, unless the court has any questions about point 2 of my brief. It's our position that this case really comes down to the jury's credibility and reliability, determining.
Well, credibility isn't really at issue. Nobody's suggesting that the victim is lying. It's the reliability of eyewitness testimony here. How reliable is it when she's identifying somebody that she saw for a very short period of time under stressful circumstances with a gun in her face?
Yes.
You would agree that science shows that those identifications under those circumstances tend not to be the most reliable?
Yes, we do have the scientific studies. I can't contest that. However, defense counsel raised many of these arguments before the jury, in particular with respect to the identification procedures here. In his summation and then on cross-examination, I believe it was Investigator O'Shaughnessy, he asked multiple questions about the RPD's policies regarding multiple photo arrays. All of this information was before the jury when they were evaluating the reliability of Ms. Goppers.
And that's the case. Look, I've looked at the wrongful convictions that comes out of this court, that have come out of this court over the years, and they're all the same thing. Well, somebody misidentified somebody. The DA standing right where you're standing say, well, the jury heard all that and the jury convicted. And we say, yeah, we're going to defer to the witness and the jury. And they end up being wrongful convictions. Now, those are few and far between. I'm not saying every identification eyewitness is bad, but I don't think anyone should sleep comfortably when somebody's doing 18 years based on eyewitness testimony from a stranger.
Yes, Judge, I agree. And in here, I believe that the multiple identifications at these, I believe it was 3 pretrial identifications. I will, of course, defer to the record if it was 4. But the victim did identify the defendant at the first photo array, and my recollection of her testimony and the record was that she didn't express doubt per se. It was more, I want to be sure, can I see, more photos to make sure that, I am identifying the right person and feel comfortable with this. And she identifies the defendant then at the second photo array and at the lineup. And as
Is it true, it is true, is it not, that when the investigator showed the multiple arrays, the first photo array was right in front of her, the one that she circled, right?
I
This is the
believe,
first array. I think the investigator showed it to her like this, right? And then a third one. Wouldn't it have been a little less suggestive is just show it separately?
again, I would defer to the record, but my recollection was the first photo array proceeding was done in the investigator's car, and then he drove her back to the public safety building where he compiled the additional ones, and I believe that they were all in front of her on a table. It wasn't him, holding up one, then the other. They were all in front of her at the same time.
Yeah, that's Ms. Whiteside's point, is that it would have been a little more reliable if you didn't show her the first array when you showed her the second one, and same with the third, but
Yes, but this court does have several cases that I cited to in my brief that say that multiple photo array procedures don't per se make the identification unduly suggestive.
I'd like to ask you about the, I'm sorry, Judge, finish the answer. I'd like to ask you about the firehouse. So before the photo array, before the very first photo array, we have the victim within minutes after the robbery going across the street to the firehouse. Mm-hmm. Two things that were significant to me that jumped out at me. Number one, no mention of the ball cap. There was never a mention of the ball cap, and we see that the perpetrator did have a baseball cap on in the video. So that's the first thing. But the second thing that seems to be, was mentioned, but I don't know if it was fully developed, the skin tone. She mentioned that the person to her right, the person that was in front of her, had a darker skin tone than the other. And it turned out that that wasn't true, that actually the defendant had a lighter skin tone than his brother. What are we to do with that?
I do think that these inconsistencies were, I would submit that they're minor, but they were brought out before the jury, and she explained, we do have some lighting situation. I believe she was seated in the vehicle, and the robber was standing outside of the vehicle and had a hood up. So I can't speak fully to that, but it was brought out on cross-examination and was in front of the jury when they were assessing the reliability.
But we're supposed to serve as a 13th juror here, right?
Yes, but also the jury did have the benefit that this court unfortunately does not have, in that they had her in front of them. We only are left with the printed record, which, doesn't, it's been accepted that it doesn't give us all of the, reliability, credibility, weighing ability that the jurors who saw her in front of them had.
And didn't the jury have a number of different questions when they were out for deliberations?
I believe so.
A number of different notes. I think it was about a 2-hour deliberation.
Yes, it was not a quick deliberation, right, to my recollection. And also, I would point out that the jury was instructed with the criminal jury instructions about cross-racial identifications and one witness identification procedures. So this was a jury that had all of this information before it, was instructed to weigh her identification with particular, consideration, and chose to find her identification reliable. And unless there are any other questions, I'll rely on my brief.
Thank you. Case number 161 is People versus McMillan. Mr. Chabro is remote. We're waiting for him to link up. Counselor, you can unmute yourself and commence your argument, please.
Okay. Thank you, Your Honor. Can you hear me?
Yes.
Okay. Your Honor, I believe that this is, Your Honors, excuse me, improper joinder of 4 separate cases. There were 4 separate incidents that happened here. On April 21st of 2018, there is a murder of an individual named Lawrence Moore. A witness was stated originally, a witness stated given his car. That person then completely changed their testimony.
Counsel, I think you're breaking up a little bit. I don't know if your microphone is on like the reactive mode as opposed to the all-time on mode, but I forget what it's called. But I think we know the facts of the case. I want to see if you could address the issue about whether the guilty plea simply forfeits the review of the denial of the motion to sever.
Absolutely, Your Honor. I don't believe that it does, Your Honor, because forfeit goes to procedural or technical issues. This is a core constitutional issue, in that Mr. McMillan is being denied his right to testify in regards to the Sabine Street shooting, where there is video of people leaving the shooting. I believe that there is a car in front of the shooting is identified as being Mr. McMillan, but there's substantial evidence that show that the shooter runs away, does not leave in the car.
Counsel, do you have, as Justice Noack indicated, we've read the facts and the record. Do you have any cases that hold that a severance motion is not forfeited by a plea? There are plenty that say that it is. Do you have any that say that it's not?
I believe, Your Honor, that the case that I had cited in my brief, Hansen, which is a Court of Appeals case, states that forfeit does not apply to fundamental core constitutional issues. And I believe when there is joinder here, which was improperly done, an abuse of discretion, especially in joining a murder that has nothing to do with the other cases, and thereby denying my client his right to testify in regards to the Sabine Street shooting, I believe that is a core constitutional issue.
So this would be,
beyond...
Counsel, I'm not saying you're wrong on that, but this would be the first case where a court has held that there's no forfeiture of a severance motion based on a plea. This would be the first, I believe. Am I correct on that?
Your Honor, I can't speak as to that specifically.
But you haven't seen any, because you would have, I'm sure you looked at this, you probably went on Westlaw, and I assume you didn't find any because you didn't cite any.
I did not see, in regards to the forfeit issue, I did not see something that would specifically as to this, but I guess I would submit to the court that I also am not necessarily familiar with joinders that I've seen that were as prejudicial as this one, and that's why I think it warrants closer inspection. When specifically there is a gun.
Counselor, 1 second. That's where you kind of lose me a little bit. It's either the type of right that is preserved irrespective of the plea, or it's not. You say it's highly prejudicial here, or the facts here matter. That's really not the law, as I understand it. That is, you either have to find a case that says, or ask us to create a case that says, like the Justice McBride indicates, that forfeiture does not apply in this situation for the first time in any case that we've had. But it matters not, right, about prejudice or the facts of the case. It's either that right or it's not, correct?
I think it does. I think that in a case where the abuse of discretion is so great and the joinder is so improper and so prejudicial to my client, especially when it's involving a murder charge that has nothing to do with the other cases to which it's joined, and is obviously being done to improperly sway a jury who would be incapable of separating these issues and looking at them separately, that I believe that it rises to the level of a core constitutional issue where the appeal is not forfeited.
Well, you would agree that some of the charges were joinable. For example, count 9 with the weapon, it's evidence with respect to some of the 4 through 6 that occurred on May 12th of 16. Some of them are joinable. You're mainly concerned with 1 through 3. You think
Correct.
should be separate.
Correct. I obviously, when there's ballistics that ties a gun that is recovered and can be tied to my client to 2 different shootings, I can understand why there would be joinder in that regard. But joining it to a murder, those things also happen over the period of essentially 48 hours. But when there is a homicide that is done where the gun is not tied to that, and there's absolutely nothing, and the people in their response say that it's proper joinder because they all involve shootings. I mean, that would, or possession of a gun. How could you have a shooting without possession of a gun? And that would seem to imply that any shootings in regards to the same defendant, same perpetrator can be joined regardless of whether they have any overlapping proof or the theories or the motives or so forth. And that is far too broad. And that's why I believe the level of improper joinder here and how incredibly prejudicial it is to my client is what warrants a closer inspection and as to whether it's a core constitutional issue that cannot be forfeited. And
We'll take a close look at that. Just to be clear, the remedy that you're asking us to impose here is to vacate his plea to manslaughter. He goes to trial on murder and all the other counts separately. He doesn't go to trial on manslaughter, he goes to trial on murder, right?
I would ask, correct. I would ask that the murder charge be severed from the other counts, correct.
And he has 2 or 3 separate trials, and he rolls his dice there. That's what you're looking for.
I think that they would be severed into 2 cases, correct.
Yeah.
And with.
We'll take a look at that. Thank you.
Thank you.
Morning, Your Honors. Brad Oser for the people. I would maintain that as we've indicated, and the court's aware, that the guilty plea here does forfeit or waive the right to appellate review of the severance. I think the fundamental flaw in the defense argument here is that if there's arguably a little bit of prejudice, it's not really a constitutional issue, but if we get to a higher amount of prejudice, it somehow then falls under the constitutional consideration. And I think that's flawed in as much as if it's a constitutional issue, it's a constitutional issue in all cases, but that's not what our law says. Our law says that if you plead guilty, you waive the right, and it doesn't implicate a constitutional right to a fair trial. It ends up being somewhat of a speculative argument because we don't have a trial here, so we don't know if it would have been fair or not.
Severance motions are before trial anyways, so
Right.
we wouldn't know anyways. But you, I'm sure, researched this issue thoroughly. Did you come across any contrary authority with respect to forfeiture?
I haven't seen any myself, no. So I would submit that the court is bound based on, obviously the court has its own precedent, but certainly it's statewide law at this point.
Thank you, Counsel.
Thank you.
Case number 164 is People versus Darrell Parker. Good morning. You are alone this morning?
Yes, I understand my opposing counsel has decided to submit, and I won't belabor the arguments here, except to say that the people's main objective in bringing the appeal is really to gain some kind of clarity as to the issue raised, and I'll thank the court in advance for providing that, whatever it can.
Mr. Hillary?
Yes.
You may want to settle in here because I think you're going to get a few questions.
Oh, okay, excellent.
That's
Okay, thank you.
fantastic.
All right.
Exactly. As I understand your brief, your point is, and it seems to be accepted by defendant, that there's nothing invalid, illegal, whatever the language is of 44.20, with respect to the enhancement based on the predicate felony, which was in turn based on a marijuana conviction. There's nothing illegal about that at the get-go, correct?
Under 44020, that's correct.
Okay. So I understood your brief relying on Smith, which relies on that case beginning with a C, Collins or something like that. You know which one I'm talking
Yes.
about, I think, right? And that was a pretty easy case to follow, at least for me, But under Smith, since it wasn't invalid at the time, you're saying that in order to grant the relief that the defendant got here, a court needs to do a retroactivity analysis, right?
That's correct.
Okay. And if we're going to do a retroactivity analysis, the first thing under Vaughn, the concurring opinion in Austin, and the Court of Appeals case, and begins with a P, Patrana or something like that, that came out within the last couple of years. In order to do that retroactivity analysis, we first start with the statutory language, correct?
That's correct.
Has the defendant cited to any language in the statute that says that the vacatur of the marijuana conviction also is to serve as a vacatur of the predicate felony enhancement? Does the defendant cite any statutory language that says that?
No, Judge, not to my...
I couldn't find it.
Not to my knowledge, no.
And there's a provision, I think, somewhere in the statute that says something along the lines of, like, there's nothing in here that's supposed to affect any prior judgments.
Yes,
There's a later
Judge.
section in there. So, I mean, there's finality to judgments, too. There's also another section that says that when somebody's been sentenced, unless it's invalid under law, you can't touch the sentence then. That's 430, whatever it is, somewhere in there.
That's correct.
So if we were to get to a retroactivity analysis, and I know I'm asking you to make the argument for the other side, where do we do that? The legislative history? How do we do that?
Well, Judge, the language of the statute is what you might consider the first prong of the analysis, and the second prong would be, is there a procedural component to the statute? If it's analyzed in terms of whether the statute is designed to ameliorate a procedural or a substantive situation.
And your argument is it's substantive, right?
Yes, Judge.
And it seems pretty substantive when you're changing somebody's sentence.
That's our argument is because it now denominates what was a felony misdemeanor conviction or charge as a misdemeanor, that is a substantive change.
Okay, and if it's substantive, it's not retroactive. At least that's the presumption that it's not retroactive.
Yes, Your Honor.
Now, perhaps here we could overcome, if that is a presumption, that is because it's substantive, it's not retroactive, but maybe we can get to retroactive by looking at the legislative history of the statute. That is, this is, and I'm going to mispronounce the word, ameliorative. And it's to ameliorate, especially on TV, I'm not going to get it right. But you know what I'm talking about in terms of getting rid of the stigma of the marijuana conviction. So we'd have to really dig into legislative history to see that this was the legislature's intent to say, hey, wait a second. We didn't just mean vacate the conviction based on marijuana, but anything that follows from it, anything and everything that follows from it. That's how we get there.
Yes, Judge. And I would add...
Should we get there? Go ahead.
That's my impression of how the court would get there. That would be the analysis the court would undertake. I do want to say, sort of as an aside to all this, that the people have presented a logical argument, or attempted to present a logical argument based on statutory analysis why this should not be treated retroactively. There is some sympathy to defendant's point of view here, or appellant's point of view, based on the fact that the predicate, which was a felony, is now a misdemeanor. So strictly speaking, we're looking at the letter of the law, the statute, and what the rules of retroactivity seem to be in our estimation. I'm not wedded personally. Our office, as I understand it, is not wedded to a particular outcome here.
You just wanted an answer one way or another. You would agree, though, that if we were to affirm, this has limited, it's not going to apply in a broad range of cases. It's going to be, there will be a number of people who are eligible for resentencing, so we'll be broad in that regard. But the only defendants who will get a lower sentence are those who got the minimum the first time around. Because somebody's predicate status doesn't affect the maximum, it just affects the minimum.
Right.
So here, the floor was 5 before as a second felony offender. If it's a first time, it drops down to 2.5 or something. If, for example, Burns gave our defendant 7, yes, he's eligible for resentencing, it's not going to do him any good. Because Burns felt that he wasn't going to give him 5 before. So there's no way he would give him. Here, this is unique in that the sentencing judge, Burns, actually said on the record, I would give you less than 5 if I could, but I can't.
Right.
There are not many cases like that.
No.
So.
That doesn't mean necessarily,
Right.
forgive me, Justice Brewer, but that doesn't mean necessarily that the court won't look at it and exercise its discretion to do a lower one, but the logic is there. I see that, okay.
Yeah, it's not part of our legal analysis, I'm just trying to, what's at stake here? How does it work if somebody is sentenced as a predicate felon, or a persistent felony offender for that matter, and the predicate is vacated on appeal? So between the conviction, then there's another sentencing, and then a vacatur of the predicate. How does that work with respect to the sentencing for the second felony offender or the persistent felony? Is that defendant entitled to new sentencing?
Are you talking, Judge, if I may ask, are you talking generically? Or
Yes,
with
yeah,
respect
not
to-
just limited to the marijuana laws, but let's say somebody has a robbery conviction, then an assault conviction, they're sentenced second felony offender, the robbery one gets reversed and vacated on appeal. Is that defendant entitled to resentencing on the assault?
I'm not sure, Judge. I'm not sure. I believe that he would be entitled to resentencing.
So why is this one different then?
Did you say he would not be entitled to resentencing?
He said he would.
I'm not sure of the answer to that. I see how if I were to say he would be entitled, that would seem to cut against any argument.
I don't know the answer myself.
But I'm not sure. I think,
it would stand to reason, for example, if somebody's serving a life sentence as a persistent felony offender,
right,
and 2 or more prior convictions, and one of the prior ones is vacated, so he's no longer, that's no longer on the books, it would seem unjust that he's still doing a life sentence.
it seems that way to me, Judge, too.
So there would, I would assume, some mechanism that you could seek resentencing on the persistency, and that's all this guy's trying to do. Is he didn't get it vacated through judicial fiat.
Right.
He got it vacated through the legislature.
I think the difference is, Judge, there you would have, in effect, have an illegal sentence being served by virtue of the invalidation of the predicate. But here, the invalidation of the predicate would be through a statute that is dealing with a substantive change in the law. You don't have that in the case of, as Your Honor has indicated, an assault conviction, a predicate, and then at one predicate or both, however many there are, is invalidated, and now he's dealing with an illegal sentence because that predicate has been
And
eliminated.
there's no issue of retroactivity there.
There's no issue of
It's just
retroactivity.
as a matter
there.
of law,
Right.
that's an invalid predicate at this point.
But
That's not
Yes.
true here, right?
That's my understanding, Judge.
Counselor, in this case, the vacator wasn't just the legislature, it was the court, also because he went to the court and had the sentence vacated, and your office didn't oppose that. But then now you're opposing the enhanced sentence.
Right. We didn't oppose, of course, the operation of the statute. I mean, the statute's designed to, let me use that word again, Judge, ameliorate a situation that was deemed unjust, I could say. The legislature decided that it wasn't going to hold a felony conviction in this case over a defendant with a marijuana conviction. But again, we're dealing with a substantive statutory allowance for a defendant, a specific statutory allowance that's substantive in nature. And so, what we're dealing with here is retroactive application of a substantive statute. And there's no warrant in the law that I've seen. And in fact, to the contrary, the law suggests that if there's legislation is substantive in nature, it's designed to affect a substantive change, that it's outside of the parameter of retroactivity.
We can't just say right here and track the language of 440.20 saying that it's invalid, because everyone agrees that when it was done, it was valid. So just
Right.
saying it's invalid doesn't do you any good one way or another.
That's right.
The question is, can we say that MRTA retroactively applies based on all its legislative history to basically be an extension is where the legislature says that you can vacate that conviction, because that's what the statute says. We're going to interpret that conviction to also mean anything that results from it, including an enhancement based on a predicate felony.
Right.
That's how we have to get there.
That's my understanding, Judge, and I'm not, the court is going to pore over the legislative history and draw its own conclusions, but it seems to me to entail an immense sweeping series of changes to unsettling convictions, that's drastic. It seems drastic in effect, and I would say that...
It's not unsettling any convictions. It's unsettling sentences.
I'm sorry, I misspoke. Sentences is what I meant to say,
That could
Judge.
be reimposed to the exact day.
That's correct. Judgments,
And
not...
again, it's only going to be the people who get a lesser sentence are going to include only those people who got the minimum the first time around, and they might not even get a lesser sentence. This is a unique case.
That's true. That is true.
And would they have to reapply, or would it be automatic because of the legislation?
Would they have to reapply
Reapply to the court?
for
to have-
resentence?
Right, or to have the conviction vacated, as in this case. The individual came before the court.
That's right. Well, if the court determines that it has retroactive effect, I would imagine there would have to be some application process. I don't know how that would work exactly, but some notice to the court, and then it would be affected.
It's not
On
an
the record.
automatic vacature.
I don't see that, Judge.
It wasn't to begin with here either.
Right.
They had to do the first step before they could do the second step.
That's
I
correct.
suppose, Mr. Hillary, that if the court were to reverse and just try to bring clarity and say that the statute should not be applied retroactively in this way. For all we know, the legislature, if they really meant what they said in murder, might very well say, wait a second, we actually meant that, so. who knows?
Exactly, Judge. And just to throw this in there to make it a little bit more complicated, I guess, is that I imagine there would be reasons why a court would not want to invalidate, even if the law had changed, even if there was a retroactive component to this, that might kind of cut across judicial temperament with respect to certain convictions where a predicate was one of these marijuana offenses, because there are somewhat different considerations in play now. It was an illegal act at the time and the defendant did it. That could be relevant to a court's determination of what the severity of a penalty should be, independent of whether the charge itself should stand based upon the new legislation that we're dealing with here. There's a whole range of considerations in play here. It's a little bit more nuanced maybe, but I definitely appreciate the court's clarity, whatever it decides on this matter.
Thank you, counsel.
Thank you.
Case 166 is People versus Williams, Giorgio Williams.
Good morning, Your Honors. Nicholas Texedo for Mr. Williams. Your Honors, the way the prosecution dealt with the DNA evidence in this case and the comments made upon it, it would be a problem even if the likelihood ratio was in the millions. Here we had a likelihood ratio of 212. That's relatively, in the reports that are seen every day, it's definitely on the far lower end of strength of DNA evidence.
It's not as low as in Wright, though, correct? People versus Wright, the seminal case here.
Correct, Your Honor.
It's much lower there.
Yes, but I believe it's still in the lower categories of
Sure.
Limited, or this one was moderate scientific support. But I think it would be a problem even if the likelihood ratio was in the millions, because it's still a mischaracterization. Here we have, it comes up in the opening of the prosecutor, it comes up during closing, but I think maybe most problematic was the direct testimony of the expert, the Central Police Services lab expert. And the prosecutor asks, so the defendant's DNA profile made up 48% of the DNA on this. He contributed the most, more than the other two. That's just complete mischaracterization of what these tests found. We have, and then maybe to make it worse, and this would go to the ineffectiveness point, counsel in his closing says the expert did not say that the defendant's profile is 48% of the DNA in the gun. Well, she did say that. She said it incorrectly, and she said that incorrectly, and it was allowed to stand because counsel didn't object to it. The case law, obviously, the court's aware of since 2015 has been trending toward prosecutors have to be careful when they comment on DNA evidence to be correct. They have to understand.
They can't say, they get in trouble when they say it's a match.
Correct.
Because that's not technically correct. But in Wright and some of the cases that followed, we had a few. The cases were based primarily on DNA evidence. Here, it would seem that even without DNA evidence, they had the people, there was ample evidence of constructive possession. The firearm was in a motor vehicle that the defendant was driving, no one else in the car. It was his motor vehicle, nobody else's. The car had been searched a week earlier, that very compartment, and there was nothing there. So it wasn't in there when he bought it.
That's right.
So isn't that, let's say there's no DNA at all. If you're in a car and there's a gun there, it's your car, you're the only one in the car, that's a pretty strong case, isn't it?
No, I don't think it is, Your Honor. The defendant testified on his own behalf. The DNA was used to establish the knowing possession. His testimony was that people use this car. It's kind of a community car that people use. And I had no idea that thing was in that compartment. I didn't even know that compartment opened. The DNA was used to refute his testimony and to establish the knowing element.
Do you think the evidence would be legally insufficient without DNA evidence?
Not legally insufficient, no, but I don't. I want to be careful. I don't think that's the analysis, though. I think the DNA, did it help the prosecution? The way it was characterized and the way it was set forth? Clearly it did.
But if the jury believed his testimony that nobody drove the vehicle without his permission and presence, he picked up the vehicle from the impound 6 days before, after it was searched 7 days before, how could it not be constructive possession then?
He would have to know that the gun was in there. And his testimony was that he didn't even know the compartment opened, and he and other people did use the vehicle. So,
but not without his permission and presence. So he would have had to be looking the other way when someone opened the compartment.
I didn't take it as he was with with people who use the vehicle every second they were in it. But yeah, I'm willing to be corrected on that by the court. But look, they didn't believe his testimony clearly. I think the main reason they didn't believe his testimony was the DNA evidence and the way it was characterized. The prosecution's pretty much entire summation was devoted to the DNA evidence. That was what they used in order to refute his testimony beyond a reasonable doubt, or to argue that it was refuted beyond a reasonable doubt. Now, the prosecution does argue that, and I think the prosecution concedes that what the prosecutor repeatedly said throughout this trial was improper. They argue that it was, just shortcuts, and it was, but I'd just like to make the point that it doesn't matter what both of the prosecutors below, what their intent was, because it's the words that matter. The words are what the jury heard. The jury doesn't know why these prosecutors are saying these words, but the jury hears those words, sees defense counsel not objecting to it, and then they don't even ask a question about DNA. They had some questions, the jury, while deliberating. Not one was about DNA. And I do want to, just to circle back to Justice Lindley's, the language used was almost the same as Wright, where they say the defendant's DNA profile. And that's what, even this prosecutor in our case, started to say the defendant's DNA and then corrected herself to say it's the defendant's DNA profile that makes up 48% of the genetic material on the gun. That's the exact language that Wright said was improper. And if you think about it, what the jury's picturing when they hear this is, okay, we scrape everything off this gun, 48% of it came from this guy. And that's just, it could not be further from the truth. And it is very harmful to somebody who's trying to establish things, is trying to attack the science behind the DNA. So unless there are any questions, I will.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, Michael Hillary for the people. I just see things differently here from counsel as to the nature of the error, I guess you could call it, the prosecutor's mistaken presentation of the DNA proof. if those were the only words that the prosecutor said, if the prosecutor had said it was the the defendant's profile that was on the item in question, yes, I think we'd be more in the ballpark of people be right. But I don't think we're anywhere near that, because over and over again, that was corrected. Over and over again, the people indicated that there was a moderate scientific support for the presence of defendant's DNA, and nothing like, a proof positive that defendant's DNA was present. I'll even read a portion of the one prosecutor's remarks to the jury. He says, the defendant's DNA profile cannot be excluded from the DNA in the mixture from the gun. It's at least 212 times more likely to have originated from the lab personnel, which we know in this case was Cody McKellar, the defendant, and an unknown person in the U.S. population.
This is the closing argument you're saying?
Yes. It provides quote-unquote moderate scientific support. So unlike Wright, unlike Rozier, there was never an assertion that defendant's DNA was on the gun. Now, it was inartful at times, I grant that. This is a very nuanced area. It requires to have some facility with scientific terminology. Easily that can be mistaken in the moment, but there was nothing deliberate, nothing flagrant here by the prosecutor.
If you keep reading, Mr. Hillary, too, looking at the DNA evidence, says the prosecutor, that the DNA evidence that the defendant cannot be excluded, viewed in the context of all the other evidence tying him to this crime, creates a logical inference that the DNA belonged to the defendant. It's just a piece of all the other evidence that you heard in order to tip the scales.
Yes, Your Honor, and I would mean to highlight that. Just another piece of evidence meant to tip the scales. A feather could do that if the weight of the other evidence is sufficient enough. I'm not saying that's what the prosecutor was saying of the DNA proof, but the point is he did nothing like magnify it beyond all reasonable interpretation. That didn't happen here.
What about counsel's point about the 48%, and so he said that was wrong and misleading?
Yes, that goes to, and I would point out the other prosecutor, I believe in the opening statement, indicated that, or corrected herself mid-course and said, the defendant's DNA, I mean the defendant's DNA profile. So clearly the prosecutor mistakenly is using these terms, but is meaning not to indicate it's defendant's DNA. And so if you take the moderate scientific support that defendant's DNA is part of that profile comprised 48% of the whole. But it's again qualified by the if. It's again qualified by there being moderate versus, complete scientific support for the presence of his DNA. There was clearly an attempt to avoid those Wright-like and Rozier-like assertions that DNA was on the item.
Thank you, counsel.
Thank you.
Case 167 is People versus Hillard Smith.
May it please the court, Susan Hutchison for the appellant Hillard Smith. With respect to point one, the people have conceded that the court here imposed an illegal consecutive sentence as between counts 9 and 10. And because trial counsel failed to object to the sentencing error, Mr. Hillard did not receive effective assistance of counsel. And under the totality of the circumstances, counsel was ineffective because there were substantial mitigating factors here. This court on appeal had knocked off the assault charge as well as a sentencing enhancement. Mr. Smith was no longer to be considered a second violent felony offender, yet counsel did not advocate for her client on his behalf. During the most important proceeding that she represented him on, she failed to bring to the court's attention that there were mitigating circumstances. Not only that, the first and second sentencings occurred in 2018. Then after a successful appeal, this third sentencing occurred in 2020. So there was a period of 2 years where Mr. Smith made substantial efforts at rehabilitation while he was in prison, and yet counsel did nothing. Counsel did not get those prison records, and but for her ineffectiveness, the trial court might have given him a lesser term. And I would also ask this court just to take a look at the harsh and excessive point. Mr. Smith was 50 years old in 2020, and he received almost 28 years. And given his remorse, given his age, given his mental health issues, I would just ask this court to, in the interest of justice, to take a look at that issue. And if there are no other questions,
Thank you.
thank you.
Good morning, Your Honors. Michael McHale, appearing on behalf of respondent people of the state of New York. May it please the court. As Your Honors have no doubt noticed in our brief, and as counsel just pointed out, we have in fact conceded their point one, that Supreme Court erred in sentencing the defendant consecutively as to counts 9 and 10. Correspondingly, since I filed the brief and taken another look at as the court is aware, the defendant has alleged numerous reasons why counsel was ineffective at that sentencing. And since the time I filed the brief, I have likewise come to the conclusion that logical consistency almost compels me to concede that point as well, that sentencing counsel is ineffective in failing to object to that illegal sentence. That said, Your Honor, I still feel that the other reasons that counsel alleges do not qualify as ineffective assistance grounds. Most particularly, Judge,
Counselor, if you concede that, and do you concede the sentence is harsh and severe?
I do not.
Does that
No.
does not follow?
No, it does not follow, Your
Because
Honor.
of the 12 stabbings 12 times, is that?
Yes, Judge. Your Honor, Justice Greenwood, I'm glad you brought that up. This was a particularly heinous crime. The evidence at trial showed that he stabbed the decedent no fewer than 12 times on the head, in the face, on the neck, all in the presence of the defendant's ex-girlfriend, with whom he had a long and tortured history. Obviously, she was the complainant on several of the other counts. His criminal history is, quite frankly, staggering. By my count, there are at least 19 misdemeanor convictions. There are 5 felony convictions. I believe there were 5 youthful offender adjudications, 2 of which stemmed from felonies, numerous attempts at probation, several violations.
Yeah, he's got a long record, for sure. We could be here for a while with that. He also could have got consecutive on the burglary and the murder, right? He could have been sentenced consecutively, but he wasn't.
Conceivably, Your Honor, yes.
Right, so
Yes,
that's two, I mean.
He could have. And I
If
would
you
just
break into
add-
somebody's house, you don't get a free crime, you don't get a free murder. Or you don't get a free burglary if you kill somebody. That being said, though, from what you just said a minute ago about you concede that counsel was ineffective at the resentencing.
Yes.
Didn't represent the client. How can we then affirm the sentence? Wouldn't we have to send it back for resentencing? He gets another lawyer, can make these mitigating arguments?
Yes, no, I freely acknowledge that the matter must be sent back to
Oh.
Supreme Court for resentencing.
Okay.
But what I'm opposing here is this court making the finding that Supreme Court sentence was unduly harsh and excessive. So
But
I'm
we
trying
would be
to-
vacating the sentence.
You would be vacating the
And
sentence?
we wouldn't then make an advisory opinion on the sentence we're vacating is harsh or not, right? We would send it back and then see what comes out of it.
Yes, and again, I bring up that record only because I think the defendant received that sentence the old-fashioned way. He, in point of fact, earned it. He likewise threatened to kill Erie County Sheriff's deputies while he was awaiting trial on this matter. He claimed to have had 3 bodies to his credit. He was found with a razor in his possession. Sentencing counsel, quite frankly, Judge, but for the exception of failing to object to the illegal sentence, was dealt a very poor hand here, and I think she did the best she could with that hand.
Usually we say someone's ineffective, not if they made a mistake, is whether the mistakes affected the outcome here. It sounds like he may have done some good things. He may not have acted out in prison. But he stabbed this man 12 times and killed him, and he has a horrific record, and he broke into a house. would if the lawyer had done all the things defense counsel says at the resentencing, would it have made any difference? I'm thinking probably not.
I would absolutely agree with that.
Well, then, but you're conceding that he should get resentenced, and we should give him a new lawyer for that.
But only on, again, Judge, I don't mean to be, Your Honor, I don't mean to be repetitious, but strictly on the grounds that there was an illegal sentence initially imposed, sort of, I don't want to say compounded necessarily, but I'll use the phrase for lack of a better one right now, compounded by counsel's error in failing to object to that at that third sentencing proceeding.
And I apologize for this, I should probably know, but I read it a while ago. Your brief, you're taking a different position today than in your brief.
Yes, and I perhaps I wasn't sufficiently articulate. Since I filed the brief, and upon further research and whatnot, I came to the conclusion that logic necessitates that I concede that.
We appreciate your forthrightness and your ability to, your willingness to look at it and change your mind. Of course, we don't necessarily have to go with your concession, but we will consider it.
Certainly.
Yeah.
Thank you.
Thanks, Rick. 169, Robinson versus Santiago. Ms. Davis is remote, as is Ms. Benedict. Ms. Davis, you may unmute and commence your argument, please.
Your Honor. Stephanie Davis, attorney for the appellate. Your Honor, I believe that the appellate should have shared legal and physical custody with the mother. I think if you review the record, you will find that in terms of housing, that they both have adequate housing. The father is now in an upstairs duplex with a bedroom for his daughter. The mother's in a 3-bedroom apartment. She has 2 of her children sleeping in the same bedroom, a son in a 2nd bedroom. She has the 3rd bedroom. But I also would like to point out that the mother has another child coming, and that will certainly make their housing somewhat crowded. I would also point out too that she says in her testimony that the father of that child, who is not the father of her other 4 children, will have no part in their lives. I would like to point out that in terms of employment, both the mother and the father have employment. The father is employed at Catholic Charities as a community service in their community service program. But in the court's decision, he's criticized for having multiple employments. Well, those multiple employments consist of Amazon when the parties first relocated to Rochester, which got them through during that period of time. He later worked as a school employee, and now he's with Catholic Charities. The fact that he's had 2 prior employments where the mother's has been consistently since June with the TSA should not be held against him. I say that he has always had employment. He's always found employment, and he's proven, and even the court acknowledges that he's proven that he can take care of the child all the way from June of 2021 through the trial in August of 2022.
Right,
Counsel?
so you want, go ahead.
Thank you. Counsel, based on the rights that were specifically given to the father by the judge, that all rights attendant with joint custody, mother shall have the duty to consult father before making any major decisions on health, safety, welfare, and that the father has independent access to educational, medical, dental records, et cetera, what more would the father gain than what he already has?
Well, my reply, and I've thought about that, Your Honor, and my reply to that would be that words matter. And for the judge to say that, well, I'm going to give him joint legal custody, but I'm just not going to call it joint legal custody. I think that that's error. I think that he deserves the proper wording. The proper wording is joint legal custody for what he's given the father. Furthermore, I do not think that the record shows that at the time of the trial anyway, that shared physical custody would have been harmful to the child.
The concern the judge expressed was the domestic violence, that we had this uncontroverted, and perhaps just one episode, but a pretty severe episode of domestic violence, and for that reason, the judge thought that precluded an award of joint custody. Why was that wrong?
I'm not saying it's wrong, but I'm just saying that reasonable people can disagree. Even this court has said that a single incident of domestic violence does not define that situation. The mother did not testify to any such altercation or domestic violence in their relationship prior to this particular incident, nor did she afterwards. I note that the father, when he testified, he said that the mother was a good mother. He offered her extensive parenting time with the child, that he sought cooperation with her. And I think that if you're going to look at continuity and stability of the child, you're going to look at the fact that this child is 3 years old at the time of trial. She turned 3 just a few months prior to the trial in August. And for the court to say that the mother has always been the primary caretaker, that's incorrect on its face. The parties moved to Rochester in January of 2021. By June, the father was the primary caretaker. And during the course of the trial, all the way up until the time that the orders of protection were lifted the next year, the better part of a year that this case took, the father was the primary caretaker. So if you're going to look at the period prior to their time of moving to Rochester, we're just looking at 1 year. And I note by the mother's
Ms. Davis, can I ask you this?
Yes, Your Honor.
You talked about joint custody,
Yes, Your Honor.
and he wants that status. It might not help him substantively, but he wants that title. You also want a change in the residency.
Yes,
You want
I do, Your Honor.
Shared 50-50, is that what your client's looking for here?
That was what my client was looking for at
Right now, we
trial,
have-
and right now he's asking the court for physical custody.
So right now, he gets, it's 3 months to the mother, 2 months to the father. Right? That can't last, the child's going to be 5 in May.
That is correct.
That is not going, it's not feasible when they live across the state from each other.
That is
This is
also
going to have to be
correct.
readdressed soon, very soon. And somebody's got to be primary. It can't be 3 months, 2 months back and forth like that, right?
That is correct.
So, and I assume, so whatever we do here is just temporary. We got somebody either has to move to the other parent's location, or somebody's going to get a lot more primary than they have now.
Well, I note that the mother has stated that she's interested in moving because she is, well, according to the record anyway, she wanted to get into the TSA at JFK, and after being there for a period of time, she would be eligible for transfer to a location closer to the Rochester area, which would have been, according to the record anyway, would be Syracuse. So things could stay as they are.
All right.
With her doing the relocation, but and
Or he could move down there. It seems like her employment is a lot more steady and gainful than his. But
well, I would not say that being in a community service program at Catholic Charities is demonstrates a lack of stability on his part. I mean, he is gainfully employed. He does live in a duplex, the upstairs of the duplex. He has stable. I'm sorry?
Stranger, he lives with a stranger, an adult stranger to the child. Child will be living with the father and some guy.
Well, the
Right.
court did not give, I'm sorry, the record did not give the sex of the individual in the residence.
Okay, some other person. But anyway, we understand your argument. Let's give opposing counsel an opportunity to be heard, if we may.
Good morning, Your Honors. Jane Yoon for the mother, Malira Robinson. Family court here properly evaluated the evidence before it at the hearing, and there's a sound and substantial basis in the record for its decision on all the factors it considered. And the question isn't whether one parent is maybe unfit for joint custody. It's, the court weighed those considerations and determined that one parent was maybe more fit, which is different from saying that the father was unfit. And the court did give the father, props for stepping up when he needed to. I'm not so sure that the record supports appellant's position, though, that he was a good father simply because he had sole custody prior to the dispensation of the orders of protection. There was uncontroverted testimony at the trial from the mother that he would often use the existence of the orders of protection against her when she tried to visit her daughter after they had moved.
There was periods of the mother's absence from the child when she left the child here and went to New York.
That's correct. That's because her job was based in New York City. And with respect to that, there was also testimony in the record that was also controverted that he did not want to move after she got that job. She had hoped to get something more local. She learned that the Rochester airport was not a federal airport, and so her options were limited as an entry level.
My point is not to make any disparaging remark towards her. What I'm just saying is that they each stepped up at different times based on the other person's need. And I guess, you might say that under those circumstances, except for the one out-of-character issue regarding the domestic violence, or that they actually were equal parents to this child, okay? Periods of absence, periods of employment, unemployment, they are all here for this child, and that's why I guess joint custody is sought, I guess a recognition that in the past that they've worked together or stepped up when the other parent needed somebody to do that.
And I think the court did take that into consideration, and just as Justice Nowak acknowledged earlier, I mean, essentially, the father does have the rights sort of associated with joint custody. I think the court was right to potentially have concerns about future decisions given the incident. I mean, yes, it's a single incident, but after that incident, Ms. Robinson moved, so there's really no reason. We don't know what would have happened. I think what is instructive is his response in court at the time the court made its decision by, responding that he hates her, I hate you, I hate you, I hate you. And so we don't know what would have happened in the future, thankfully.
Okay, so, all right, the point was brought up that the child is going to be 5 in May. And so where the child goes to school is a decision that's on the precipice. Okay?
That's correct.
Is there any pending litigation regarding that, going on at this point in time?
I'm not aware of any pending litigation. I am aware, however, that I believe the father has moved from the state. That's my understanding.
Moved out of New York State.
Yes, that's my understanding.
So he no longer lives in Rochester?
My understanding I don't know where he is presently. My understanding is subsequent to these family court proceedings, and under Michael B, I believe this court can take it into consideration that he did spend some time in North Carolina. I don't know if he's there right now, but I know he was there at some point during the pendency of this appeal.
Thank you. Ms. Benedict.
Thank you. May it please the court. To Attorney Yoon's point, my office was unable to get a response from either parent in an attempt to meet with our young client. So with respect to the school age time, the mom does have primary placement. So it would be my position that the child would stay with the mother in the Bronx, if that's where she's still living. I assume she is, and attend school. But the referee did state in his oral decision that the school breaks when my client did start school would be spent with the father. So that was not reflected in the order, but it is in page 141 and 142 of the record. The referee did say school breaks and the summers. So I I would ask the court to acknowledge that the decision controls over the order and make that a part of the order. I don't know where the parents are. I don't know where the child is. In multiple attempts to contact these parties with no success. But with respect to the issue of joint custody or sole custody, the AFC at trial did support joint custody. I'm not going to fall on my sword over that, but I do believe that this record would support an order of joint custody. There was the incident of domestic violence. However, I don't know that that qualifies as an embattled and embittered set of parents here. And the father did get very emotional, obviously, at the end of the hearing. I'm not clear if he directed those statements to the mother or the referee. I've spent enough time in family court that, trust me, the judges do get those kind of remarks. So I'm not clear who the father was addressing. So other than that, unless the court has any questions, I'll just rely on my brief.
Thank you, Counselor.
Thank you, Judge.
Next case for argument is 170 Rochester Regional Transit Authority versus John R. Stensrud.
Good morning.
Good morning.
May it please the court. John Reformat for John Stensrud and Maria Stensrud. I'd like to take a step back before I get into the heart of my argument to recall that this case is about just compensation. Now, counsel, with all due respect, in their brief, RGRTA, emphatically said they've already received just compensation. In fact, they said we've already received more than just compensation. Now, as to that point, we all understand that there's no cross appeal here, so they can't seriously be contending that Judge Doyle awarded too much. But one of the key points about just compensation is that it's an issue for courts, okay, at the end of the process. And here, the elephant in the room is that the only methodology, the only valuation report that can provide just compensation, and its magnitude is greater than anything we've seen so far, was performed by a finance expert named Ralph Eisenman. Now,
but Counselor, as you correctly just pointed out, it's for courts. And your argument in your brief is the court incorrectly made adjustments, downward adjustments. But isn't that the court's role? And didn't the court in its decision lay out its justification for that?
It is, Judge, and I should have been clear. My reference to just compensation is for courts, specifically in that case, was because there's a lot of talk about market value. And this court, 4 years ago or 5 years ago, has already decided the market value issue. But that came up again in the brief, so I just wanted to address it.
I think everyone agrees just compensation is almost always market value, but there are some limited exceptions. Just compensation, market value is just compensation in most cases. That's what the case law holds. But
that's correct.
Here, your argument seems to be the only appraiser was Wren. Mr. Wren, the RGTA's appraiser did not testify. He used a sales approach, which is not appropriate. This is income capitalization. Wren comes up with two income capitalizations. One he calls investment value, and one that he calls regular. He did the same calculations. He did net operating revenue divided by capitalization rate, and he had two calculations. The second one was what he called investment value. We said in the last appeal, none of us were on that last appeal, but my understanding of what this course said is that investment value is income capitalization with different numbers plugged in. Would you agree? Is that what
I would not agree. They're both income approaches to value, and I will acknowledge that the terminology gets tricky, okay? There's only one income capitalization in this case, and it was done by Mr. Eisman. The others are all income approaches, Judge Lindley. But thank you. It's a good question, though.
So his income capitalization, he came up with 420. Mm-hmm. He goes to your client. Client's not happy with that number. So then the appraiser goes back to the drawing board and comes up with investment value. and he changed the cap rate from 8.11 capitalization rate to 6.36. And he also changed net expenses. He didn't count there was no management fee, and the difference was the real property taxes. He assumed that they were going to stay absurdly low at 63,500. That's the only difference between his two income approaches, or if you will, investment value and income capitalization. He just changed the capitalization rate and he changed the expenses.
Well, he makes some other assumptions about, he takes the actual expenses and he makes them quote-unquote market expenses, Judge Lindley. I mean, I understand what you're saying and it's a fair point, but he does make some other adjustments that take it away from the actuals to, frankly, I wouldn't even, they're numbers that are not accurate. And here, my client had a property that clearly outperformed the market. To hold him to market value in a situation, alleged market value in a situation like that, is not just. It's certainly not just compensation.
Well, if he's getting better returns, you mean his rents are higher?
Yeah, his net operating income
is
revenue
higher.
minus expenses, yes,
Right.
sir.
Well, if someone's looking to buy that piece of property, wouldn't the purchase price be reflected in his great returns that he's getting?
You would think that it might be a little bit higher, but it is nowhere near what it would be based on pure income capitalization. Take the actual revenue, subtract the actual expenses, and apply an appropriate cap rate. That's not what happened here, and that's the problem. The only report that did that with the proper methodology, including the federal methodology, is Mr. Eisman's. Now, I know we can't go back necessarily right today and address that, but what we can do is look at what Judge Doyle did with respect. And Judge Doyle, the lower court made up an assessment when we had about 15 years of actual historical assessment, all right? He did not use the actual assessment. He also didn't use the actual management.
Well, let's focus on the assessment.
Yeah.
The way that Judge Doyle looked at it, contrary to Wren's investment value, Wren assumed the property taxes were $4,150. $4,150 is assessed at $63,500. For a property that your client he claims he put in almost $600,000. Matter of fact, he notified Carlos Caballada at the city of Rochester. He put all this money in there. And Wren assumed in his investment value that forever and ever, the assessed value would remain $63,500. Judge Doyle looked at it, and there was some talk, and I mean, it's outside the record, but the city of Rochester reassesses every 4 years, and it's 100% equalization. Matter of fact, they have done a reassessment since this case. They did it in 2020. Judge Doyle looked at it and says, it's not realistic to assume the city's not going to catch up with you at some point. And look at all this great value you brought and raise your taxes. Judge Doyle raised them to only $12,500. If the city were going to do it based on market value, according to your client, he should be assessed at $695. Doyle assessed them at, what, $240 or something. So that's really what you're saying is Justice Doyle made a mistake in assuming that property taxes were going to go up when he should have just assumed, despite the hundreds and hundreds of thousands of dollars your client put in, he's always going to be taxed at that absurdly low rate.
I understand. The way you put it, it sounds funky. But the reality is it had not increased. And the reality is, in that neighborhood, the assessments do not increase, all right? But further, Judge Lindsley, as of the taking date, that's what's important. 2015 is the taking date, the taxes as of that date.
And then on the management fee, Judge Doyle factored that in. Your client didn't pay one because he did it himself.
Correct.
Essentially, he paid himself. He was the manager. It's a lot of work to manage properties.
He paid himself, but he's not getting paid.
Right. But he was doing the work, the management fee. He had to do all the contractors, he had to get tenants, he had to do the leases. So he didn't charge himself, but somebody else who comes in, unless they do it himself, that's a fee that they would have to pay. And Judge Doyle recognized that. You're saying that was error, that we should just assume there's going to be somebody else who wants to work, who wants to be the landlord and do all that work too. Judge Doyle didn't assume that.
In an assessment case, we would have to do what you just said, not in a condemnation case. My client is entitled to the full value of the property to him. This is not an assessment case where market comes into play. The actual value to my client is set forth, not actually in Mr. Ryan's report, but that's the closest that we have to work with right now.
Any further questions? Thank you, counsel.
Thank you.
Your Honors, may it please the Court, Tim McMahon. the issue of investment value came up. And I just want to point out that the expert in this case conceded that investment value was not market value, right? He acknowledged that that was a subjective value. And I think that's exactly why Judge Doyle eliminated that from his consideration in this case.
Do you read our prior decision as saying income capitalization is the same thing as investment with different numbers plugged in?
I think so, Your Honor.
That's what we said.
I think so, yes. And I read it also that that issue could go to the court. The court can assess the weight of that testimony. And now here we are, the standard review being, you know, viewing the judgment in the light most favorable to sustain the judgment. I think he came up with 509. We're not happy with 509. We considered taking an appeal from the 509. 430 was the market value that was testified to. That's the number that we believed was supported by the evidence. 695, as conceded by the expert in this case, was not market value.
Did they not get additional income under 701 such that the total amount paid to the property owners was $773,904?
Are you adding the additional allowance to the ultimate?
Under 701 of the...
Yeah, they did get an additional allowance. I'll defer to your math combining the five.
I think if I did the math right, he walked away with $774,000 for a house that he purchased for $50,000. Now granted, he did a lot of work, he gutted it, he put money in.
Yep.
Judge Doyle said the only reason he didn't go with the income capitalization that Wren used with the 420, which was his income capitalization.
Yes.
The only reason Doyle didn't go with that, he said it would be unjust due to the money that was invested, the $600,000. There was no evidence at trial of any expenditures to that nature. Mr. Stenrud didn't testify, there were no receipts of anything. No, he's an honorable guy, and maybe we take, but this is a court of law, we don't take people's words. There was no evidence at trial how much he actually spent. And then Judge Doyle, but then gave him the benefit of the doubt that that was true. So he said, I'm not going to go with 420, which is what your own expert says is income capitalization, because you claim, you didn't prove, you claimed you spent $600,000, so I'm going to give you more than what your expert says. I'm going to go 509, based on evidence not even in the record. In other words, you might have a better, a cross appeal might have been a better option, stronger argument than what he's got.
I understand that completely, Your Honor, but we are here today to find finality. We're here today to get an affirmance. Viewing this judgment in the light most favorable to sustain it, we believe that this court should affirm the judgment. Thank you.
171, Restani versus Universal Properties.
May it please the court, Brad Hunt from McKinsey Hughes for the defendants who are the owner and operators of the Mexico Food Pantry. What I would like to do is focus on the plaintiff's arguments at a very specific level, and I think that's important because the plaintiffs wrote their brief with some general language, and when you look at this in general terms, it can sound like there's an issue of fact, but when you focus on the specifics, our position is that it's pretty clear that there is not.
Well, let me tell you, this is my understanding, that the plaintiff was on a wooden stoop and walked off of that stoop and then stepped in a hole that was covered or concealed by something, by some kind of mat. Okay? Am I wrong or am I?
That is plaintiff's argument.
Okay, so you're saying the facts are different than that?
I'm saying the issue in this case is not how the accident occurred or whether there was a defect. That's not the issue here.
Okay.
The issue for purposes of summary judgment is simply whether we created the defect, the alleged defect.
Well, the
or
issue is whether that's a question of fact on that issue.
Yes, exactly, whether there's
You would have to establish as a matter of law.
That we did not create
Got it.
that's the issue, not whether the hole existed, but whether there's an issue of fact as to whether we created it or had constructive notice. And constructive notice is closely related to creating the hazard, because to show constructive notice, the plaintiff needs to show that it was created so that it existed for a long enough time, as well as being visible and apparent for us to have knowledge of it. And
by the same token, if you created it, then you had actual notice of it.
Oh, absolutely, and that's right. So, here's what I think is important to understand. The plaintiff's arguments on both creation of the hazard and, constructive notice are basically, in very general terms, that we did construction on the site, and this construction involved digging. What I think is important to understand is that there are really 3 specific instances in which the plaintiff says that there was construction or digging, and none of these took place in the critical time period in between when the food pantry opened at the beginning of May 2019 and when this accident happened at the end of July 2019. So I'd like to just quickly address these all 3 of them because
Hold on a second. Let me.
Yes.
This is your motion, okay, for summary
Correct.
judgment. Okay? And so you had the burden to prove that the property was in reasonably safe condition.
Yes.
Okay, and that's what the court said you didn't do, okay? That the depression in front of the stoop concealed by a mat, you were not able to prove that with the existence of all that the property was in reasonably safe condition.
So I think we did meet that burden, and that's the only fair reading of the record. And what I would point you to is the deposition testimony of the owner of the property, John Sharkey, which is unrebutted. There's no evidence to refute it. That at the time that this platform was installed, the platform off of which the plaintiff stepped, at the time that it was installed, he said that they leveled and compacted the surface. Those are his terms. That's on pages 1039 and 1040 of the record, and nothing rebuts that.
But counsel, that's 4 months before the accident. They did that in April. The accident happens in August. All that time, those 4 months, you've got people coming in and out of the pantry on a regular basis. You've got this gravel, which had been filled from time to time as necessary whenever there were depressions in the parking lot area. And I would give you the fact that maybe that's not right by the entrance, but maybe it is. Don't we have to assume, for the purposes of the motion, that the mat was a black mat, not a white mat, but a black mat, because that's what the plaintiff claimed. Plaintiff and her son claimed at the time, meaning somebody put it there. And the claim is there was a hole, and somebody put a black mat over a hole. And then she stepped in the hole and broke her ankle. Why isn't it that simple?
Because there's not, for that time period, and I think it's, for the period between the opening of the pantry, which was end of April or beginning of May, and the accident, there's no evidence that work was actually done in this area. The only evidence is that many people came to the food pantry and went from the food pantry without having any problems or incidents whatsoever on this platform. The work that they describe, you had the work that I just mentioned around the time that, in connection with the installation of the platform, and it's the unrebutted testimony of the owner is that they leveled and compacted the surface at that time. Then the 2 other instances in which they claimed that there was work, one was filling in areas in the parking lot where there were depressions resulting from delivery trucks back in March before the pantry opened, and that filling in work was done again before the opening of the pantry in May. And the third one that they point to, and the plaintiffs don't cite the dates here, but they talk about Mr. Sharkey's deposition testimony in Exhibit 3 that refers to the work of a contractor doing some digging. That was from November, months after the accident when they paved the area. It was a gravel parking lot, and for the relevant period, the only evidence in the record is that there was no problem. People came and went without any incident at all.
You're asking us to assume that this dirt and gravel area in front of this wooden platform, this sort of makeshift wooden platform awaiting the final construction, that remained exactly the same for 4 months, outside. Despite rain, weather, snow, people coming in and out. You're asking us to assume it remained exactly the same because they haven't proven that there was construction in that area.
I'm not asking you to assume that it remained exactly the same. I'm asking, the question again is not whether there was a defect at the time, it's whether we created it or had constructive notice of it. And I think that's important because the unrebutted record shows that it wasn't defective at the time the platform was installed.
I'm sorry about this. Stop right there. This is where I'm confused. You seem to be arguing both paths. You've told this court so far this morning twice that you're not arguing that there was no defective condition.
Right.
But now you're saying there was no defective condition because it was leveled. So it's almost like you're saying, well, it was leveled, therefore that dangerous condition didn't exist, but you know that on summary judgment, you essentially have to agree with the plaintiff's testimony that such a defective condition did exist. So if it did exist, isn't there a question of fact about who created, given the testimony in pages 1055, 56 of the record from Mr. Sharkey, whatever his name is, that he had to dig into the gravel and add some and detract some?
No, I don't think there is. He specifically says that digging was in connection with the installation of the platform. That's what he says on 1055 to 56. That was, in April before they opened, and that's when they leveled it. And in fact, he said he says this on 1055, the reason for that digging was specifically to make the area level. That's why he did it. And, we're not arguing that as a matter of law, there was no defect. Maybe something happened in that time, but there's no evidence at all that we created it or had constructive notice of it.
But once you go down that path, as you did in your brief, and your point one was basically there was no evidence created, but that's we have legions of case law that says simply pointing to gaps in the other side's proof is not enough. You have to prove as a matter of law that you did not, in fact, create the existing dangerous condition. And how do you do that when there's all this shifting of gravel back and forth? I'm not saying it's a great question of fact, but there's at least a question of fact that should be tried.
But we submitted evidence that we leveled it when we installed the platform, okay?
Which means there's no defective condition.
There's no defective condition then. And then the evidence further shows that we didn't do work. We didn't have delivery trucks coming in the intervening period until long after the accident occurred when they repaved it. There was no evidence of repairs that we did in that time.
All that means your argument is that there was no defective condition.
There was no defective condition when we installed the platform, and there's no evidence that we created the defective condition at any time there. We didn't do further work. The record reflects no means by which we could have created the condition.
Let's assume that you didn't create it, and I stepped out for a minute, so forgive me if this question's been posed, but let's assume you didn't create it. There's a mat over, the allegation is there's some evidence that there was a divot there, a little hole, 3-4 inches deep at the base of the step. There's a mat over that, suggesting somebody's trying to cover it up. Wouldn't that suggest actual notice of the divot, if we're going to assume that that's a defect?
No, I think the opposite. I mean, the mat was put there when they installed the platform to have a mat over the gravel. At the time when we know, based on the unrebutted record, that there wasn't a defect. That wasn't thrown there in.
So it was
later.
fine. There was no divot. You put a mat on it, and then somehow a divot is created with a mat over it?
That's the plaintiff's argument. We don't concede that there actually was a defect, but but that is the plaintiff's
if we get the constructive notice, this divot is not going to occur in a blink of an eye, right? It's going to be over time. People come down. It's not going to be something that's overnight. Wouldn't that give rise to at least an issue of fact? Nobody's talking about who wins as a matter of law here. It's just what the jury can consider. Over time, shouldn't they have noticed that there was a divot there?
Well, I think the answer is no. I mean, first of all, that doesn't, if it assume it did get created over time as people came and went, that's not us creating it, so then it becomes a notice question. And there's no evidence and no argument really of actual notice. So the question is constructive notice. And, it's really 3 months. It's a 3-month period. I would submit that we had no duty to, check under the mat.
Could you clarify this factually for me about this divot? Is the divot underneath the mat or on top of the mat?
Under the mat.
It's under the mat, right? So the mat to the plain eye was level, essentially.
Correct.
But when you step on it, you would notice that there's a divot. It's flexible mat.
At least that's what
the plaintiff's argument.
Right. You step on it, and presumably people going in and out, including people who worked there and owned it.
Well, but again, the record reflects that many people did go in and out, and no one other than this plaintiff did notice.
Nobody fell. We don't know if nobody noticed.
Right. Well, right, there's no affidavits in the record that say, we noticed this divot, we warned them, and there's nothing like that.
And there's an affidavit from the director of the food pantry, Martha Sturts, that says, many people came and went, did not complain. We did not know, did not have notice of
Right,
it.
there's no opposite affidavit, is my point.
Correct.
Right.
Correct. You know, I mean, the plaintiff herself and her family came and went and admitted that many times, including earlier that same day when they, on their trip in, they did not notice.
Right,
any
they may
problem.
have they have the burden of proof at trial, you have it here. So they
We
may
have-
have a hard time proving that, but we don't, as Justice Curran indicated, we don't toss cases on that basis.
Understood, but again, you know, it's not our burden is to prove that we didn't create the hazard or have notice of it.
Yeah.
I would, you know, I think that this court's decision in the Anderson versus Justice case is instructive. That involved a dock through which a plaintiff fell, and this court actually, you know, reversed the trial court and granted summary judgment to the defendant. And the question was constructive notice. What's the duty to inspect? And you know, this court said that that's a, you know, the question of how often you have to inspect a you know, facility is very fact specific, but it was decided as a matter of law in that case. This was a dock, and what this court said in Anderson was one annual check in the spring is fine and then is sufficient, and then the property owner is entitled to rely on the experience of the many people coming and going. You know, I would argue that this case is an even stronger situation because what we're for finding that we didn't have constructive notice, we're not talking about a dock or some piece of equipment. We're basically talking about the ground underneath a mat. And only you know, 3 months passed between when we leveled that ground and when this accident occurred, during which many people, including the plaintiff herself, came and went and did not experience any problem.
Let me ask you this. We deal with this often, and it's always a little unclear. Let's say you have 3 arguments with respect to the notice issues. 1, it was created. This is what the plaintiff says, in which case you don't need actual or constructive notice. 2 is you say no actual notice, no constructive notice. Let's say we agree with you on creation and actual notice, but we think an issue of fact or you didn't meet your burden on constructive. Do we narrow it at trial so that the plaintiff can only go to trial on constructive notice? We toss out those other 2? Or if you get one, is it like serious injury? You get one injury that's serious, you bring everything in. How does that work?
It seems to me like it would be appropriate to narrow it at trial.
So you could win partially, and
Right.
if we were to find, say, no actual notice.
Right, I mean, if this court were to issue a decision saying that, you know, summary judgment should have been granted in all respects except for constructive notice, then,
Right.
yeah, I would
aren't-
want a jury
Right.
instruction at trial saying that.
They aren't
you know,
causes of action, though. So we're not dismissing a cause of action. These are theories based on a cause of action. But I know we've done it both ways over the years. And
It's different, yeah, it's different arguments. I mean, I certainly expect that we would take the position that we should get jury instructions that limit the
figured you
trial
would,
that way.
yeah.
All right.
All right. Thank you, counsel.
Thank you.
Next case on the calendar for argument is 173, Looney Injury Law Firm PLLC versus Salino Law Firm LLP. Both are remote. We have Mr. Walsh. We're waiting for Mr. Paycheck. Paycheck, good morning.
Good morning, Your Honors.
You may commence your argument, please.
Thank you, Your Honors. We are here today on this appeal because we have 2 identical proceedings moving through the New York State court system seeking an allocation of the attorney's fees in an underlying personal injury case. The first proceeding was the subject of an appeal in this court's, I think, December term, where the court allowed that case to proceed, which is assigned to Justice Panapinto. In fact, in that case, hearings were held, evidence was received, and we are simply waiting a decision on the allocation of attorney's fees in that case. After that proceeding was commenced, 3 months in fact, A subsequent proceeding was commenced and then assigned to Justice Devlin. That is the subject of this appeal. And the remedy for this situation, which is frankly quite untenable, is 3211A4, because we clearly have, not disputed, two identical matters proceeding through the court system, which could result in disparate results, conflicting results, and 3211A4 cleans this up.
Mr. Pajak, before you continue, can we just clarify one thing? In the respondent's brief, they indicate, it's not part of the record, but they indicate in their brief that Justices Panepinto and Devlin have conferred, and they ultimately determined that Justice Devlin will decide the fee dispute in this case. That's page 8 of the respondent's brief. Do you care to comment on that?
Yes, I'd be happy to. That's not accurate. I know the two justices have communicated, but quite frankly, we did our post-hearing submissions to Justice Panepinto, and this case, the Tiante Smith case, was part of those submissions. So Justice Panepinto never said, I'm punting this over to Justice Devlin. They did talk. I think there was some candid, they were honest. There was some confusion among them as far as the outcome of that conversation, but there has been no, first of all, there's no ruling, there is no order, there is no anything indicating that Justice Devlin is in fact hearing it. We have no hearing in front of Justice Devlin, and Justice Panepinto heard all the proof that there was, took all the evidence, and again, everything's been submitted to Justice Panepinto. Now,
that's outside the record. Mr. Pajak, that's outside the record, right?
Yes, it is, Your Honor. It's clearly outside the record. And on this record before this court,
But
you have two.
Hear me out, just to be clear. Both points are outside the record. What you just told us about what's going on in front of Justice Panepinto is outside the record, and you put that in your brief, and Mr. Walsh put in the other thing that the two judges have concerned. All that's outside the record. I mean, this is now appeal number 3 by lawyers fighting over fees. And by my count, there are 8 other appeals in the pipeline for this court on this similar issue. When is this going to come to an end, gentlemen?
I would love it to have come to an end already, Your Honor, quite frankly, but the minds have not been able to meet and resolve.
Well, that should happen. I think both lawyers would agree on that. But anyway, I didn't mean to cut you off, Justice Nowak. Thank you.
Oh, thank you. Just in terms of CPLR 3211A4, I mean, it has built into it this discretion, make such order as justice requires, that language. And, you know, you can certainly appreciate that sometimes in the underlying case, the judge has a lot of knowledge, has worked with the attorneys for years, has a lot of knowledge as to who did what, and sometimes they don't. Sometimes the case comes in, RJI is filed, and it's ripe for settlement right at the moment. So in 2 different cases, one judge may keep it, the other judge may defer, as we've seen some of the other judges in the 8th Judicial District do. What's wrong with that general notion that there's flexibility intentionally built into the law to accommodate both situations?
Well, I think that flexibility is absolutely critical here, but that flexibility here should be exercised. And if you look at again, the context of the case, meaning the case in front of Justice Panepinto is submitted, the flexibility here would allow this court to modify the order and have the case transferred to Justice Panepinto so that there's one consistent result based on the evidence that was received by the court.
Mr.
I
Pajak?
certainly recognize that there's usually...
Mr. Pajak, let me bother you for a second, okay? Something that you both spent a lot of time in your briefs talking about is that first in time rule. And if we're just looking at the fee request, you'd be the first in time, okay?
Correct.
Now, your opponent suggests that we go way back to the time that the personal injury action underlying this fee application began. And so I know you can't speak after your opponent speaks, so I'm asking you to speak to that. Why should we or shouldn't we go back to the beginning of the case that Judge Devlin had, which would predate your plenary action?
And Mr. Pajak, Mr. Pajak, 1 second. I also want to hear the answer to Justice Mattis's question, but just make sure you tie into part of your answer Section 475, the very beginning of that section says, from the commencement of an action, that's the underlying personal injury action, is when the lien attaches. So in connection with the first in time rule, since the lien attached from the commencement of the personal injury action of Deontay Smith, why is that not the proper commencement date for the analysis? So you got a lot of
The answer
questions
is
for both of us.
right. And I was trying to take some fast notes here. So the answer is you can't use the original date of the underlying action while the lien does attach under 475, because that's where the attorney or attorneys or firms did the work on that case. The reason the first in time rule does not go back to the original pleading in the underlying personal injury case is a jurisdictional one. And that is because the court in the
Mr.
underlying
Pajak,
personal
please
injury
tell me which case says it's a jurisdictional issue with respect to the first in time rule. We know for a fact that our case law says that the attorney has one of two options, in the underlying personal injury action or a plenary proceeding. So it can't be jurisdictional where one is not allowed and the other is, because they are both allowed. Do you have a case that says it's jurisdictional?
Yeah, the jurisdictional issue I mean is this, Your Honor. The court in the underlying personal injury case, the parties are the plaintiff versus defendant. The law firms themselves are not parties to the action. It requires the filing of either a special proceeding under Article 4 of the CPLR or a plenary action for the court to obtain jurisdiction in the sense over the attorneys and that dispute, which is a unique dispute, fundamentally different from every issue in the underlying personal injury case. The court does not have, in the personal injury case, jurisdiction over that dispute among the attorneys. So that's why the first in time rule ties into the filing relative to that dispute. When that petition, notice of petition or petition is filed, that's a jurisdictional device to have the court obtain jurisdiction over the attorneys, or a separate summons and complaint so that the court again obtains jurisdiction over those parties. So that's the reason why the first in time rule cannot go back to the original personal injury filing date, because that court didn't exercise jurisdiction. It was different issues, completely different topic. And I certainly understand, I think one of your honors mentioned the deference or the discretion that's normally given to the motion court on a 3211A4 motion. But if this court does not change the outcome of the order here, again, we will have two cases proceeding through the court system with two disparate outcomes. And there are ample avenues this court can either reverse and dismiss this or transfer it over, whichever would be in the court's discretion, certainly here, but that would remedy the situation, maintain consistency in the court proceeding, and allow one ruling to come down relative to the allocation of the attorney's fees.
Do you agree, Mr. Pajak, do you agree that the first in time rule is not a hard and fast rule, that it's flexible and it's just one factor among others?
I agree with that, but again, applying it here, particularly when the first in time case has essentially been tried, it makes no sense from a judicial economy standpoint to let's do it all over again in front of Justice Devlin. We did it, evidence, hearing, and all of that. So we have a completed package just waiting a ruling from Justice Panapino. So I agree it's not a hard and fast rule, but here it just is illogical in my view to go and now let's do it all over again in front of Justice Devlin, because we already have it as a completed package here. So,
Mr. Pajak, do you remember Justice Del Conte's solo dissent in one of the last cases? And did you happen to pick up on the fact that in that case he cited to Russo versus City of New York, which specifically states that the Supreme Court in this situation retains jurisdiction over the fee dispute? So I think that pretty much rebuts your argument with respect to jurisdiction, given that citation.
I'm aware of that citation, Your Honor, but frankly, I don't think I agree with it entirely, because again, the attorneys are not parties to the underlying personal injury case. And think of the vehicles that are utilized to bring a fee application to the court. It's a special proceeding. I mean, it is a new legal proceeding, You don't do it outside of that, or, as Justice Bannister mentioned, the plenary action. Those are your two avenues. So respectfully for that case, Your Honors, I don't think it's correct. I'll be honest with you.
What about all the case law that was also cited, one case in particular, Justice Del Conte's dissent, that specifically says, and there are at least a dozen cases I found from the Second Department, that says the trial court in this situation, the Supreme Court, is in the best position to evaluate the factors. So in other words, there's no harm here, there's no discretion, there's no legal error for Justice Devlin to keep it, because she, as the trial justice, is in the best position to do it. So that certainly supports her discretion in keeping it, correct?
I would agree, but not in the generally yes, but not in the context of this case, given that we have a closed and finished hearing in front of Justice Panepino. Again,
that's all outside the record, Mr. Pajak. I'm sorry, that's all outside the record, and there's some dispute about it.
Right, and look, we would be rewarding the judge. Let's say Devlin went ahead and just did a hearing real quick and then said, well, we already got something here. We don't, it's not who rushes to get a decision first out.
The Justice Panepino case was filed in July of 2022. What you'd be rewarding here, if you don't make a different decision and reverse this, is you'd be rewarding somebody who started an action, a proceeding 3 months after the first one, knowing full well that the first matter had already been commenced. That's what you'd be rewarding here. And I really do want to touch on this notion that the trial judge is uniquely equipped to handle the subsequent fee dispute. And respectfully, I'm going to suggest that absent an actual trial, that is not the case. Judges who are having a case go through their courtroom from pre-trials, 1,000 cases, 500 cases, whatever the current caseload is, that underlying trial judge doesn't know about any of the discovery items that were done. They don't know how many depositions were done. They don't know who was deposed. They don't know how long the depositions went. They know nothing about the communication back and forth to the client. There is really so much that a trial judge is completely unaware of up until the point of trial, when that's the full show and there's the judge sitting there with counsel, and that judge, I would agree, has a unique vantage point to understand what's going on in the case. And quite frankly, half the time pre-trials are not even had with the trial judge. It's the confidential law clerk. So the court itself, the judge, has actual no awareness of what's going on in that case, because my understanding is I don't think the confidential law clerk runs in and tells them what happens in every pretrial. They're just moving the case along. So I think that's really a false premise, that the underlying trial judge is in some kind of unique position, short of a trial.
Thank you, Mr. Pajak. Your time is just about up, but we'll give you a chance to wrap up, and then Mr. Walsh can be heard.
My only wrap up, Your Honors, will be, unless there's any further questions, I will rely on the remainder of my brief, but I think this is one of those unique situations where the only logical outcome is to reverse and grant the motion to dismiss, which will allow a consistent result to be obtained regarding the allocation of attorney's fees.
Thank you. Mr. Walsh.
Thank you. May it please the court, I'll try to be brief. I think the court is aware of the issues. This is not an abuse of discretion. Dismissal is not required. Judge Devlin properly exercised her discretion. She's decided 2 other cases that were assigned to her. First in time rule doesn't always apply. It's not an inflexible rule. And here there's some debate about who's really first in time, given what the questions from the court, both Justice Kern and Justice Bannister. I would note the one case they rely on, the Cassar case, was a case involving Salino and Barnes where the motion to dismiss was denied. So it doesn't really provide any authority at all.
And you know who the trial judge was?
Yes, Your Honor.
That was me. Yeah.
And I don't know if that's when Justice Panepento was your clerk, but let's go.
That was a long time ago, by the way, Mr. Pajak.
I know. I'm sorry.
Mr. Walsh, what do you make of the argument that we have proceeding from Justice Panepinto, who's about to render a decision, it sounds like? She's already gone through and done the work. If we affirm this, then Justice Devlin's going to duplicate that, and we're going to have 2 separate rulings, will we not?
Yeah, we're going outside the record again, but I'll answer your question. In the submissions we filed, I specifically said, based on the record and the discussions, we are not submitting the Tiante Smith case to you because we understand Justice Devlin's going to decide it.
And in any
So
event,
I
Mr.
try to
Walsh-
stay within the record.
Mr. Walsh, in any event.
That
if
horse is out of the barn by now.
If that were to happen, and again, we're all outside the record on all of this, if that were to happen, one decision could be collateral estoppel or res judicata on the other. It's not that hard.
Understood.
So, I mean, in terms of going forward, now, Mr. Walsh, you indicate that it's all abuse of discretion. In the event that there are future appeals involving, for example, Justice Greenan, we would apply the same standard of review with respect to whether or not such a motion has been granted or denied. We'd apply the abuse of discretion standard, correct?
Yes, and we're probably going to drop those appeals because Justice Greenan was not the justice assigned originally the case. He picked it up later. So I don't think our argument that the trial justice who observed all the work really helps. So there's one other case we didn't appeal, Judge, and that was the one with Judge Caruso, because it was his discretion to decide that he would dismiss. So we didn't appeal that. We recognize his discretion, and I think Justice Devlin should be applauded for saying, I'll do the work to get this done, instead of shunting it off to somebody else.
Okay.
Just as a follow-up on Justice Curran's question about, one's going to be collateral estoppel on the other, how are we going to decide that? So we have one that says one attorney gets 30%, the other judge says, that same attorney gets 60% of the fee, and we have these two. You say, one's going to be collateral estoppel. Do we then apply a first-in-time rule? And if so, why don't we do that now?
Well, because we're going outside the record again, because these justices have chambers right next to each other, and they've been talking a lot about this, about what the circumstances were that this would go forward. And I don't want to get outside the record anymore, Judge. It's just that
I'm talking about the risk, the risk of it.
Well,
The risk
no
that
risk.
we have
if one judge decides it, the other judge might say, okay, I don't need to decide it anymore. There's a lot of ifs or buts. But with this case that we filed was returnable in December of 2022. We didn't start taking proof with Justice Penapento until August of 2023.
And Mr. Walsh, just for the sake of clarity, my example was that one got decided first, not that there was two separate decisions, but that one got decided first. A party could then make a motion to dismiss on the basis of collateral estoppel so that the other court didn't go forward. That was my only point on that.
Sure, I understand that.
I have one more question, Mr. Walsh. Okay, the notion that Mr. Pajak talked about with regard to the trial court being in the best position to evaluate all the work that's been done by each of the parties, he dismisses that notion, saying that there's so many things that the trial court doesn't know. And I just wondered what your comment would be about that notion.
There's no authority for that, Your Honor. You don't have to go to a trial. There's a lot of work, as all the justices know, that happens in chambers with law clerks trying to get cases resolved, so you don't have to have a trial. And that's what most of these cases are.
All right. Thank you, Mr. Walsh.
Thank you.
Case 174, Wright versus County of Monroe. Holbrook, good morning. We're waiting on Mr. Schumacher, who we had on the calendar to appear.
Yes, Your Honor.
Have you seen him?
I see that he had checked in. I have not seen him since my arrival.
We will deem that submitted. And you may be heard if you wish. You are asking us to affirm, I assume?
Yes, Your Honor. Samantha Holbrook on behalf of the plaintiffs Denman and Sonia Wright. And yes, I am asking the court to affirm the decision of the court below, as it's our position the judge correctly decided that the plaintiff had stated a cause of action sufficient to allow the matter to proceed. It's a pre-answer motion. No discovery has been conducted in this matter whatsoever, and the complaint clearly lays out the facts of the matter, the circumstances, and the applicable case law. And the complaint also alleges special duty on the part of that the defendants owed a special duty to the plaintiffs.
And the answer to all that will happen at trial or be developed during discovery, correct?
That's correct, Your Honor.
Right. Judge Vazana did not rule that there was a special duty. That would be summary judgment. He just ruled that there's sufficient facts from which a finding could be made. This is very early, and we'll see how it comes out at summary judgment and at trial.
That's correct.
I think we understand.
Okay. Thank you,
Thank
Your
you.
Honor.
Case 175, William Rauch versus Precision Shooting Equipment Incorporated. Mr. Collins, good morning to you.
Morning, Your Honors. If it please the court, as the court knows, I represent plaintiffs' appellants William and Carrie Roach.
Mr. Collins, good morning, good afternoon, whatever it is, it's right on noon, but is it part of your position, your brief, that irrespective of whether this is destructive testing, that whatever they plan to do, it's not material and necessary? Is that part of your argument?
That is definitely part of the argument.
Would you bring me to that point then, at least for my sake, please?
Yes. The case law I cite in the brief, states that to conduct testing that involves alteration of a product or a similar item in a case involving product defects or something akin to that, the party seeking to make that alteration must establish that it's the only method by which it can obtain the information it seeks. And here, Precision, the bow manufacturer, failed to establish that. Its expert who conducted an initial inspection of the bow in 2018, rather in 2022, said that to examine the bow, he wanted the opportunity to examine the bow in a state that should better represent the condition that it was in. He did not state or establish that it was essential to Precision's defense to conduct such an alteration, followed by the examination that he
But back to
proposed.
my question, Mr. Collins, and I need to take you back to this point.
Yes.
From a little bit I understand, they want to, this is a layman's terms, this is the best I can do. They want to reassemble the bow, restring it, and basically make it like new again.
Correct.
I don't see what point that serves, getting back to material and necessary, because they could have an exemplar. They could have, why rebuild it to make it look like new? Because if you do that, that doesn't mean that it's like it was at the time of the accident.
Correct.
It was presumably had some manufacturing or design defect at the time of the accident, and if they build it to make it look like new, what good is all this?
Yes, and our expert, we did submit an expert by Dr. Batzer, who said that an exemplar examination could give them the precise information that they want. And in fact, in their respondent's brief in this case, the defendant, in arguing why plaintiff would not be prejudiced, said alteration of the bow is not impactful, as plaintiffs argue, as a similar failure could be easily replicated on a similar compound bow. So I think that cuts both ways. They're saying that, you could use an exemplar to do exactly what they want to do in this case, which is, show how a new bow works. And this is not.
I'm not sure, but the question is how is that relevant to the trial, showing how it works? I wasn't clear from their papers. It's a problem for them, not you. How is that going to aid the jury in any sense or form?
As you said, that's defendant's argument. I don't want to speculate and maybe make an argument that they wouldn't make as to why or even if it would be at all material and relevant. Because what we have now is a bow that, according to defendant's own expert, has a broken cam or wheel on it, part of this cabled pulley system. The cables derailed at the time of the accident, ended up blinding, the plaintiff, either with the string, which is separate from the cable, or a cable striking him.
So
but we have it in its, we have it.
The question at trial will be, why did it malfunction? How did it get that way? Did the plaintiff do something to cause it to be in that condition, or was it manufactured, designed in that way? And going back and fixing it, doing that recreation, I guess the question is, how is that going to aid in determining how the bow got in that defective condition?
I don't think it would, because it wouldn't show exactly how this bow, worked at that time, or should have worked, or how it would have worked at some time in the past. What's, essential here is, obviously the burden is on plaintiff to show one or more of the categories of, defects in a products liability case, but showing how a bow, an exemplar bow in like new condition, fully repaired would work is really no more relevant than taking a car that had a defect, putting all new parts on so it worked the way it, was supposedly intended to work. What would that really show in terms of,
The jury's not going to be able to see the bow that is allegedly defective here because they're going to destroy it, essentially.
They would alter it by, what they intend to do, they propose, is replace the broken cam, restring it, and then put the cam back on. But they certainly made no representations that that would result in a bow with the string and the cabling system in the same position it is now.
That's what they say they're going to do. They say they're going to fix it and then break it again to the exact same condition it was in before. And
right, which I think would be prejudicial.
If they can do it with another bow, it'd be totally necessary. We understand your points. Why don't we let your opponent answer some of these questions?
Thank you, Your Honor.
Good morning, Your Honors. Kevin Krupa for Respondent Precision Shooting Equipment. I want to touch on a point that the court raised that, we are not making this bow like new. What we're simply doing is taking the damaged top cam, and what we want to do is simply take the damaged top cam and put a new cam in there so our expert can assess the alignment of the cams and the limb balance. That's something we can't do now, and that's something that we need to do in order to assess why this bow malfunctioned, what the defect is.
But if you replace the top cam, let me back up.
Sure.
The top cam is the allegedly defective item, correct?
No. The top cam, my understanding is the top cam was damaged when it was dropped at the time of the accident. There's no defect has ever been particularized. We don't know if they're claiming a design defect, a manufacturing defect. It's just all very broad. And to touch on the point of the exemplar bow would help us, decide whether or not there's a design defect, okay? It won't help us decide and determine what a manufacturing defect is, because that's particular to this specific compound bow.
Well, to that point, see, you can see where I was, that if you're going to put a new top cam on it, and if the top cam is in defective condition, you're essentially making it like new. Again, I don't know what these things look like, I haven't used them. But so that's where I was coming from, my question, Mr. Collins. Now, if you're telling me you're going to replace the top cam as part of your testing, and you don't know what the defect is, whether it's manufacturer or design, what good does that testing do you now until you know what the alleged defect is?
That allows us to test what the alignment is of the cams and the limbs at different draws, at, mid-draw and full draw. We're not doing a test fire or anything like that, but that's what needs to be done in order to assess this compound bow. And Judge, I'm not an expert on this, and that's why I'm relying on Mr. Cooper. So he has told me, and this is what Judge Hanna decided, that we could do this so we could fully assess what the claims are in this case.
But in addition to the top cam being replaced for the testing, it's also going to be restrung.
Correct.
All right, so we're going to have some changes to it. Right now, without this additional testing, plaintiff's expert could show the actual bow to the jury and say, this is the damage, this is what we're claiming the defect is. Your expert could show the same bow to the jury and say, this is where we think it was dropped, and this is how you can tell the damage was dropped. Nobody can do either of those if we allow for this destructive testing. We take that evidence away from the jury, don't we?
I don't think so, Judge, because if we're allowed to do this further testing, we would be able to videotape it, first of all, everyone would be present. And also, this particular compound bow, there's probably at least 200 photographs of it since the time of the accident. So they're certainly going to see this compound bow in its condition at the time. And I think it's going to be, our expert is going to put it back together the way it was immediately after the accident. So the jury is certainly going to see this bow in the condition it was at the time.
They can take the
or
strings
immediately
out?
after
They're going to take the new strings out, put the old ones back?
Yeah, we're going to put it back together how it was.
How do we know they have the expertise to do this? Have they ever done that with this type of a bow? That's, this is quite an operation we're talking about.
Well, my particular expert, he's been with Hoyt Archery for 10 years. He has patents on cams for compound bows. So I think if anyone can do it, he can.
Then
I mean, you asked me.
It's destroyed. But
I don't
he says
think
he can build an exemplar, so why can't he do the testing on the exemplar?
Well, the exemplar, again, it only goes to the design defect. It doesn't go to the specific defect in this particular bow that they're claiming. Because we have claims for design defect, manufacturing defect, which is specific to the item. And
But on the same token, then, what would be shown to the jury wouldn't be the exact same thing anyway.
as opposed to what?
As the original, because.
Before the accident, you mean?
Well, the original bow that you're testing. The one that you're testing is going to be altered and then restrung, right?
Well, it's going to be tested and restrung as part of the testing process, and
Right.
then it's going to be put back together with the components that are on there right now. So it would be the same as it was before.
Shouldn't you know the alleged defect before you do any of this? Before, I mean.
Hasn't
first do no
been
harm.
alleged to us, Judge.
What's
So,
that?
you know, hasn't been alleged. I mean, they haven't particularized what this defect is.
I looked in the record, I didn't see a bill of particulars or answers to interrogatories, so we don't even know what the alleged defect is. If we allow you to go forward this, and it really does destroy the item and alters it permanently, we've done a lot of harm. I mean, the court has done a lot of harm. Why not wait until you know what the alleged defect is, however you pinned them down, bill of particulars, interrogatories, and then reapply?
Judge,
No?
this is the last item of discovery in this case. I don't know if that was clear from the record or not. But we have interrogatories, nothing's been particularized, all the depositions have been done.
Do they have an
This is-
expert who posits a theory here?
The only reason I know they're expert is because they opposed my motion to compel this testing. I don't have an expert report or anything like that. We're not at the expert disclosure stage yet in the case.
Well, Justice Curran raised a legitimate point. At some point, they have to disclose what their theory is, maybe for the first time at trial, but.
Well, I think at
might
that
be-
point, I mean, I think we're entitled not to have trial by ambush in this case. It's
Right.
part of the reason we want to do this testing, to
Well,
figure out what's
plaintiff's
going on.
expert gave an affidavit, right? Plaintiff's experts in the record about this being destroyed, because your position was it wasn't going to destroy your expert's position was it wasn't going to destroy the bow.
Yeah.
But it was the plaintiff's expert that said it was going to destroy it.
That's what the plaintiff's expert said, but
Right,
then,
right.
you know, I only know his identity because of that affidavit on this discrete issue, not as far as what his opinion
That's
is.
as much as they submitted.
Yeah.
Do we have it right, there's nothing in this record on appeal? I mean, you just told me something brand new, or outside the record too. I didn't know it was this far along
We're
because I didn't.
specializing in going outside the record today.
Yeah, apparently.
I apologize.
Setting a bad example here. But I don't see anything in this record, including from the plaintiff's expert, that identifies their theory of the defect vis-a-vis design or manufacturing. Am I correct that it's not in this record?
That's correct. And what you'll see in that record, though, I think if you review the prior motion papers, my predecessor, Mr. Brower, commented on the fact that, listen, they haven't identified what the design defect is. They haven't identified what the manufacturing defect is. They haven't identified what warning should have been on this particular bow. So at some point, they have to identify these things. And here we are. I know it's outside the record, but we're at the end of discovery in this case. And this is the last thing that we need to do. And I still don't have this theory identified as to what they say went wrong with this bow.
We understand. Thank you, counsel.
Thank you, Your Honor.
This court is adjourned.